Today, yet again, we have witnessed another display of disregard of court orders. Miguna Miguna was not produced in court this morning as had been directed by Lady Justice Roslyn Aburili yesterday, and again this afternoon after Justice Odunga's orders. In his ruling today, Justice Odunga found CS Matiang'i, IG Boynet, and acting immigration boss Munyoki all guilty of contempt. Yet again. This is not the first order to be ignored in Miguna Miguna's case, and tonight we will show you that the trend is in fact not unique to Miguna's case. A trend that prompted Chief Justice David Maraga in February this year to issue a firm warning in which he accused the executive and the police of interfering with the independence of the judiciary, thus jeopardizing the administration of justice in the country. Maraga termed it a damaging trend that is completely against the Constitution. Tonight, we will discuss what should happen to institutions and individuals who ignore or delay the execution of court orders, and most importantly, its effects on the rule of law in the country. That is the big story tonight. Good evening and welcome to the show. I'm Yvonne Okwara Matole. Talk to me using the hashtag #TheBigStory on Twitter. First, I want you to listen to that very strong statement that was made by Justice Odunga just earlier this evening.
Apart from contempt of court proceedings, this court must ensure that its orders are complied with. The matter before me is no longer a dispute between the parties, but has now reached the level where judicial powers are on trial, and the dignity of this court is being questioned. This court cannot just fold its arms while the respondents continue to cut work on its orders. In the premises, I make the following orders. First, second, and third respondents have by their conduct been contemptuous of the orders of this court, and they are convicted accordingly.
He went on to say there is no immunity to impunity. This is that statement that we referred to a short while ago from the Chief Justice David Maraga that was dated the 7th of February, reads in part, "Courts are temples of justice and the place of refuge for those seeking protection. They must never be despoiled either through physical transgressions or blatant disregard of their pronouncements." It further continues to state that compliance with court orders is not an option for any individual or institution. Neither is it a favor to be doled out to the judiciary. Rather, it is a crucial matter of constitutional and civic obligation. Judges and magistrates are at liberty to invoke the legal avenues available to enforce those orders. So we'll be talking about that tonight and why those orders have not been enforced despite some of those strong statements from members of the judiciary. My guests tonight, Counsel Akusala Boniface, who's an advocate of the High Court and also a council member of the Law Society of Kenya. Also joining us tonight from Kakamega, Elisha Ngoya, who is a teacher and practitioner of the law. And we will hopefully be expecting Dr. Eric Komolo from the City Centre studios. But let's go straight to our lead reporter tonight, Sophia Wanuna, who is going to talk to us about the very latest in this case, but also, more importantly, to be getting reaction from government. Sophia?
Good evening, Yvonne. Yes, as you mentioned, that ruling earlier from Justice Odunga, and one other thing he mentioned is that this has stopped and ceased to be a matter between two parties, and that now is judicial powers that is in question and is on trial as well. One of those very significant statements that came as he read out the ruling earlier this afternoon. So finding those three senior government officials in contempt, that contempt card issued to Interior Cabinet Secretary Dr. Fred Matiang'i, the Inspector General of Police Joseph Boynet, as well as the Director Immigration Kihalangwa. And this is the second time they're being required to appear in court tomorrow, failure to which, however, he said he would go ahead to issue orders against them. And of course, Yvonne, Miguna Miguna continues to be in JKIA hold up there. Remember yesterday, Justice Aburili had issued that order for him to be released and appear in court today. That did not happen. happen. Again, even this morning, Justice Odunga had said that he should be presented in court at 2:30. It did not happen as well. So several of these orders out there, and hence perhaps those sentiments coming from the judge that this has now even gone beyond being a matter between the two parties and putting the justice system in and of itself and its powers and the directions that come from it into question, or at least into a sense in which the questions are being raised, in which way that is going to be looked at. So tonight we are going to be speaking to, and I'm joined by the Secretary, Digital, State House, that's Dennis Itumbi. He tweeted moments after Justice Odunga's morning ruling requiring that the three senior officials, Matiang'i, Boynet, as well as Kihalango, appear personally in court, not send representatives, not issue affidavits as they've done before. And soon after he tweeted, and you tweeted just 2 words. Break that down for our viewers.
Brutum fomen. Basically, a court cannot order that a chicken that is cooking in Yvonne's kitchen to first of all wait for it to lay an egg. It's already cooking, man. It is overtaken by events.
In this sense, overtaken by which events? Cooking in what sense?
First of all, Miguna is on the airside of the Kenyan airport. You're well-traveled, and I'm sure KTN reporters, editors are well-traveled. You cannot even have an argument in a foreign airport. Or even, by the way, a Kenyan airport, when you come from outside and you have lost your passport. Once you arrive at the airside, you have to apply for those documents to be able to be allowed to get in. You don't get in first and then you start applying. You apply for temporary passage and then you're allowed to get in.
All right. You talk about application. Let's go to the orders that were issued by the High Court. And the orders were to ensure that the Directorate of Immigration give Miguna documentation to allow him to get in, to facilitate that. There was no application. Actually, the word is not facilitate. I get it wrong, but it was a word to just ensure he gets in. There was no onus or requirement on the Mr. Miguna. It was given to the Director of Immigration to ensure he comes into the country.
I would recommend after this interview you look at the orders again, which I've looked at carefully. The word is facilitate. Mm-hmm. Facilitate in simple English definition is to make it easy. How do you make it easy? Mm-hmm. Give you the first thing that Kenyan government did immediately Miguna got in was to give him forms to be able to, was to request for his Canadian passport, yes, which he had given in Canada before he traveled, right, which was his traveling document, so that he can get a visa. Mm-hmm. He declined. Mm-hmm. Kenyan government did not give up. Kenyan government spoke to Canadian High Commission, who gave their officials to go and convince Miguna that they would actually hold the passport, mm-hmm, take it to the immigration officers, because Miguna's fear was that government would snatch the passport. Right. So government allowed for diplomats from Canada, mm-hmm, to hold, to which again, after 3 hours of persuasion, right, Miguna declined. Government of Kenya did not give up on trying to facilitate. In the afternoon, they sent forms for citizenship, yeah, so that he would fill them, and therefore, on that basis of nationality, get a passport and ID.
Yeah, allow me to jump in, because I've just opened those orders. The word is not facilitate. I have them here. Order number 4, issue Miguna with his document. This order number 4, the first. Yesterday. This is not. This was 26th. This was Chachamuta, 26th of February. Read. Issue Miguna with his documentation to allow him to come in, yeah, so that he was out of the country. In the span of a month, he was to be given his documentation. Failure to which to be facilitated then to get in. So there was no application or requirement on his part.
That's again, you don't get issued by something you have not requested for. I mean, for him, for government.
The court has directed you to.
No, but I mean, how do you issue you with, we are in a setting of a hotel. How do you issue you an order of a steak when you have not ordered for steak? We have to issue something which...
The court has ordered you to issue Sophia a steak. Let's give that example then. So why do you need me to restate that I need steak?
Sophia appears without steak, without teeth. How does he eat the steak?
I think now we're...
No, it's the truth. I mean, you see, Lenaola actually handled this matter very well in 2014 in a ruling, which I have with me here. And in that ruling, he clearly said, and this is the same court we are talking about. So it is important that 35 of Renaola's ruling. I need not to emphasize the point that dual nationality was not recognized by the repealed constitution or any statute enacted pursuant to section 97 aforesaid. I jumped there, and then he said, due to that, this was a British, it was a Kenyan with a British nationality at the time. So he says, due to that, the lawful fact is holding British nationality and a British passport under the repealed constitution and having neglected and refused to apply for a Kenyan passport, means that what that guy had an identity card like Miguna, he says means the Kenyan passport that he holds is invalid and he would be best advised to surrender it or face criminal sanction.
And I do not question that, Itumbi, tonight. I think all agree with that. The question here is, following that, Mwita's judgment, the first was that the finding of the Interior Ministry that he's not a Kenyan citizen was suspended. The finding of the Directorate of Immigration to destroy his passport was suspended. He was to be given back his passport, pending hearing and determination of the matter. So that all of that is all suspended. Yes, you talk about dual citizenship and whatever the Constitution said, but all that stood suspended until these matters were canvassed in court. So why wouldn't the government continue to engage in the courtrooms and obeying the orders that have since been issued?
You know, during the first question, I was actually trying to tell you government has actually been trying to ensure that happens. And I had reached a point where I had told you he brought forms and Miguna declined. This morning, government went further and asked the Canadian High Commission again to go to Miguna, and government extended something we call a courtesy visa. When you're a senior government official and you travel to another country, they give you a courtesy visa. So despite Miguna not being a senior government official of a foreign country, government extended a courtesy visa so that Miguna is able to get in and apply for all those things and be able to get them.
Okay.
So government actually did that. But the most fundamental thing here, Sophie, and it's important for us to canvass that. In Chacha Mwita's orders, which you've given me right now, he also ordered that the Kenya National Human Rights Commission oversees the process.
Right.
Can you ask yourself, why has a court, having had a court order that was done by the same court, why have they not summoned the Kenya National Human Rights to explain whether the court assignment was followed to the letter?
So you appear to have an opinion on why, so tell us.
No, I don't have an opinion. There was a court-assigned officer. I don't have to have an opinion. All what the court needs to do is to summon that person. I mean, as media, you should look at all those angles.
We will look at those, but at the end of the day, the directions here are from the courts to direct respondents. And I go back to this. Are you saying tonight, because I have, and I will make this as a statement, we have reached out to all the offices as respondents. They have declined to appear on camera tonight. We thank you for taking the time to be with us. But are you saying the government position is that whilst directed to issue Miguna with documents to return to the country, is that you require for him to apply, which he contests?
I mean, you know, if Miguna contests, that cannot, as to what Miguna does, he has advocates to speak to him. But as from a government's point of view, the order, by the way, that order, I've just looked at it again, has 3 words on facilitate. So the key word in the whole of that order is facilitate. So government has done all that is possible to facilitate Miguna. Miguna has declined. So I'm telling you, this is what is now going to happen. First, court cannot issue orders in vain, in practical orders. How do you expect an interior cabinet minister to go after a person who is legally not in Kenya?
But that interior secretary did supply and send an official to Miguna with paper, so they recognize he's there.
No, they recognize there's a gentleman who has problems, and the Interior Secretary tried to assist him get out of the problems. But the court then cannot come out and say, that gentleman with problems, we don't care whether Kenya government has processes. In fact, the only mistake that the IG of police and the Director of Immigration and the Interior CS have done, the only mistake the court is saying is that they have protected Kenyan sovereignty.
How have they protected it?
By ensuring that immigration vets everyone who is coming through it.
But this is the thing. If Miguna Miguna and his lawyers have contested this, if he applies to get into the country as a Kenyan citizen, it goes against the matter that already is before court, which he argues he's a Kenyan citizen. He doesn't need to apply. So if he applies, he goes against already the case he's made in court for which he has gotten orders in his favor.
Article 14.5 of the Kenya Constitution reads in English, layman English, it doesn't require a court order, says this: a person who is a Kenyan citizen by birth and who on the effective date has ceased to be a Kenyan citizen because a person acquired citizenship of another country is entitled on application to regain Kenyan citizenship.
And we do not contest what you're saying. I think here the issue is the interpretation of what the judge has ruled. That at the end of the day, like today, bring Miguna to court. Why hasn't he been presented to court? Martin
Luther King once said, even a bad law, the best treatment of bad law is to resist it. If a court orders, a court cannot order that a horse that is dead carries the carriage in your wedding. That order is impracticable. It is not possible to be enforced. It is an order that is made within the realm of fantasy.
And that is not the first time I'm hearing this from authorities in government, that these are not sound orders, some orders cannot be complied with. But what then precedents are you setting for an ordinary Kenyan sitting and watching, who in their own matter decides, I don't think this is sound, I don't think this works out, I don't think this is practicable, starts talking about dead chicken and horses? What then to them if the government cannot obey an order?
No, you cannot say the examples I've given you are not about dead horses and chicken. I mean, if a horse is dead, a court cannot sit and say that horse must pull the carriage in your wedding. That is a fact. If that happens to an ordinary Kenyan, it's an order that cannot be implemented.
So today, the Inspector General of Police and the CS could not leave this pass-out parade to be in court to uphold the rule of law.
Judge Odunga is guarded by policemen who graduated out of a police pass-out. A police pass-out is an important issue. It's actually an important event attended by the President of Kenya. You think the President of Kenya did not have anything else to do than attend a pass-out, 3 of them in 1 week? It is a very important thing.
But on the other occasions, they have been required. Of the other occasions, they've been required to be in court, and they did not show up.
They gave the reasons why. In all those occasions,
there are always reasons.
My friend, you know the CS of Interior and the IG of Police are not errand boys. They are public servants working for this nation and to ensure security. We are going to the Easter season. Do you know how many terror attempts have been stopped in this country? It requires the security sector to be seated. You cannot be having a court that just issues orders and demands personal appearance, and then in the afternoon it decides, no, actually I didn't mean personal appearance. I actually meant anyone else can appear. Maybe the CAS, maybe the PS would have appeared. Forgetting that is like giving an order to a pilot who is already piloting a plane to Mombasa, and just before he lands, you decide that pilot should appear in court.
So there is never a space in their calendar at any point they would adhere to a court order at any point.
Maybe there is space, only that space was not today.
I'll ask you this question as we take it back to Yvonne. You sued the government, having been arrested and detained over allegations of hacking into the ICC email. Would you say, outside of all of this noise in this matter of Miguna, his detention, the court orders that have been issued, that this is unfair?
That is for a competent court of law to decide. When I was arrested, 40 police officers came from nowhere, stopped my car on the highway, arrested me, pushed me to another car. I did not resist. I did not bring issues of bring your ID. I didn't say my ID has been lost. I gave them my ID, said search my house. I said I need a search warrant. They gave me a search warrant. I allowed them into the house. They searched. And after that, I moved to court and won my case. It is the rule of law. You cannot have the rule of law when it favors you and the rule of law when it doesn't favor you.
So at the end of the day, as we take this back, your sentiment, because you're saying government officials are too busy to appear before court. You're saying that Miguna has been given opportunity to apply, but these orders still are not being obeyed in regard to him being presented before court,
Sophie,
irrespective of all this, him being presented before court.
Sophie, before I answer your question, today I haven't followed about how many officers of government appeared in court, but yesterday 14 government officers across Kenya appeared in court. So I'm not saying government officers are too busy. In fact, the Solicitor General was in court today and he was denied audience. I am not saying government officers are too busy to appear in court. I am saying...
You're saying the ones required to appear are too busy.
No, I'm saying the ones required to appear today were in an important national event.
And after which... Been throughout... This is not the first time they've been required, Dennis.
The GSU pass-out parade started at 10 a.m., ended at 3:15 p.m. At 3:30 p.m., there was a National Defense Security meeting, which they all attended. At 4:30, just a minute.
But this is today. The other occasions,
At 4:45 today, we were swearing in the DPP and we were swearing in the Attorney General, who is involved. You know that government has adopted a joint effort in fighting terror. So all these people sit in that committee. So they attended on the basis of that.
So what should the country expect in regard of the matter of Miguna Miguna? Because clearly it appears tomorrow they will not be coming. They must be attending some very other important issues.
This government is a government that is guided by the rule of law, is interested, and the president himself has said, the deputy president has said, is interested in obeying every existing law. But even government cannot obey an order that is not practicable to implement.
Who decides that, Dennis?
Many people. KTN News, which we are broadcasting on today, you cannot be given an order now not to do the interview with Itumbi, which has already happened. I mean, the orders must be practicable. If today someone publishes, and God forbid, publishes a naked photo of yourself or of any other female presenter in KTN on a newspaper, which is all circulating at 6 a.m., at 10 a.m. the court cannot say that newspaper must be withdrawn because that newspaper has already sold and gone to people. So those orders must be practicable and there must be orders that can be followed. Otherwise, they lay in the realm of fantasy.
Thank you very much. Really appreciate your time. Dennis Itumbi, Digital Secretary at the State House, saying orders must be practicable for them indeed to be complied with. Yvonne.
Sophia Wanuna, thank you very much for that. Like we mentioned at the start of this show, indeed, that is not the first court order. We just want to take you very quickly down memory lane of a number of court orders that have either been ignored or whose execution has been delayed, sometimes for over 10 years. So let's start with, recent events. And we start with February 2018. Okay, let's start with Miguna Miguna's case. The Inspector General of Boynet ordered to release Miguna Miguna. They did not. He was then deported. You will remember that. He was to be released on a 50,000 shillings bond. Boynet was to appear in court. He did not do that. That was a little earlier this year. So let's take a look at other court orders in other cases. In February this year, the court ordered the Communications Authority to restore live transmission of the 3 media houses during that shutdown. The Cabinet Secretaries Musheru and Matiang'i were also cited for contempt. The TV stations were switched off in January. That's on the 30th after Raila swearing in. Omtata went to court. They took quite some time. It was about 5 days before that court order was actually obeyed and complied with. But then later on that month, the Director General of the Communications Authority was himself to fall afoul or become victim to this matter. He was barred from entering his office despite getting a court order that lifted his suspension. I want to take you back now to 2016. Then Cabinet Secretary Willie Bett was found in contempt for seizing vehicles that belonged to the Agricultural Sectoral Coordination Unit. They were seized despite a court order prohibiting the same. In 2015, this one you will remember, PS Karanja Kibicho was found in contempt for disobeying a court order that required the government to pay 2.6 million shillings to a Nyayo House torture victim. He was then jailed in absentia for 3 months. He is still a free man today. A warrant of his arrest was not executed. At the time, he was in the Ministry of Interior. A similar demand, by the way, had been made of Boynet's predecessor, that is Kimayo. It was made 3 years before by the same judge, was never obeyed. In 2014, President Uhuru Kenyatta led an operation to blow up a ship that was packed with heroin worth 1.3 billion shillings. At the time, government was trying to prove their tough stance against drug trafficking. That ship and its contents were part of an ongoing case. The magistrate had ordered the drugs be destroyed, but not the ship, as it was still an exhibit because of a pending application. Now, that ship was blown up in the high seas in the Indian Ocean on the same day. The then president of the Law Society of Kenya, Eric Mutua, criticizing President Uhuru Kenyatta for leading that operation, terming it in bad taste and also in contempt of court. Now, I want to take you further back. In 2008, October, the High Court ordered the Teacher Service Commission to process teachers' pension based on the 1997 salary award. The government took 18 years to obey this court order, finally availing the funds just last year in 2017 was about 17 billion shillings. This affected 22,000 retired teachers who had to wait well over 10 years for their dues. So this shows you, this is not just about Miguna Miguna. Something is clearly going on within the country. We have my guests with me tonight. I want to take a short break, but first I just need to get some really quick reactions from my guests. I want to begin with you, Elisha Ongoya. What do you make of everything that's been happening in the country up until this point with respect to court orders? Are they becoming useless orders, useless documents?
Of course, Yvonne, thank you so much for the opportunity. What's happening in the country at the moment is unfortunate. It's unfortunate because, one, it's happening, and two, it is receiving certain very dishonest justifications, like the type we've just heard from the Director of Digital Communications. And I'll not make any further comments on the comments I've heard from the Director of Digital Communications, the presidency, because number one, each of the statements he made were less than honest. And number two, I also am not sure about his capacity, intellectually speaking, to comment on legal matters since he's a Director of Digital Affairs. Court papers will not become useless pieces of paper. It's upon the people of Kenya to remain eternally vigilant. The price to pay for justice is eternal vigilance. And these are universal principle, not just applicable to Kenya, but the world over in the realm of justice. That's what I can say for now.
All right, let me get your views, Eric Komolo. There's somebody on, a viewer here on Twitter, at Mburu Mose, who says, as much as I don't support disobedience of court orders, I equally castigate judicial activism where specific judges are readily shopped, quote unquote, to handle particular cases with anti-government interests. Your response and your comment to that?
Well, I literally share everything that Elisha said, the other side. The gentleman seems to talk about judicial activism, but he doesn't appreciate why judges will continue to issue certain orders. And you know, talking specifically of Miguna's case, it has a history. Specific judges have issued orders, they have been under attack, and these orders have not been obeyed. So this is not really judicial activism, but an attempt by the judiciary to assert its authority in terms of enhancing rule of law in Kenya. I must also say that it's very unfortunate that all this is happening at a time when there seems to be some political stability coming back, and when we really need to focus on bigger socioeconomic issues. And anyone who's studied international law and who has studied international development will tell you that immediately you cast aspersions on rule of law, then whatever agenda you have may not be realized. I'm not going to comment on Dennis Itumbi because I don't think he knows what he's talking about.
Akusala, are court orders subject to interpretation, or should they simply be obeyed? And then perhaps you can present yourself to the court of law and explain your circumstances or disagree with it.
The first instance is to ensure that compliance happens. First of all, let me start with a brief response to what Mr. Itumbi is talking about. This is the unfortunate situation that we are finding ourselves in when we have given bloggers the chance to interpret our constitution and our laws. This is a preserve of the courts. And if you look at Article 1 of the Constitution, delegation of power by the people has been given to the executive, the legislature, and the judiciary. Each part plays their own role. Now, in case a party is not pleased with provisions or rather orders of court, there are avenues of seeking, varying those orders or setting them aside through the same judicial means. That is what our constitution demands. Therefore, it is unfortunate that right now government is playing politics in matters that are purely administrative and indeed legal. That is what I can say for now.
Take a quick break. When we come back, we will talk about what happens and the enforceability